Hello everyone, I'm Jennifer Arganaraz with New World Title, and today I'm going to be interviewing, asking some questions to Sylvana Rosende from Rosende Law. She is a probate attorney, and we're going to get down to the nitty gritty on what realtors should be doing or not doing when they have a property that is in probate. Thank you, Sylvana, for being here.
Thank you for having me. So I am an estate planning, probate, and guardianship attorney. I handle everything transactions regarding probate sales and everything what happens when someone passes away and they're still on title.
So this happens a lot. Should a realtor list a property that has not gone into probate, meaning the person that is deceased is still on title and nobody else?
So that's an interesting question, and my answer to that is going to be do your research and absolutely not. If you have someone on title who passed away, who hasn't gone through probate, they need an executor appointed to have the legal standing to be able to sign off on that contract. So usually a contract, we have the executor who signs off, who can list the property, who can enter into a sales agreement and all of that.
Sylvana, there's a question I get a lot because people want to usually quitclaim deed a property into an LLC for protection. Would you say an LLC or a trust is better?
So the way that I structure these is that it's two separate documents. I mean, when you have an LLC, that's for protection. That's what protects your assets. And when we think of a trust, we think of a trust mainly for testamentary provisions. So the way to do asset protection is definitely through an LLC. So if you have an investment property or property you rent out, you want to put it in an LLC and then assign it to your trust so you can circumvent probate.
Oh, that's good to know. If you have a will, what's better, a will or a trust? Because they're two different things. So people automatically think, oh, my mom died, but I have a will and she's appointing it to me, and they think automatically they don't have to go through probate.
Right. So a will and a trust are completely different, mechanisms for estate planning. A will is just a guide for the judge to say, this is how everything should be distributed. The way to avoid probate is through a trust. However, I'm not the attorney that's going to tell you that everybody needs a trust. I don't think so. I think that you can accomplish a lot through a ladybird deed and not necessarily have a trust for every person. And through a ladybird deed, you're also staying away from probate.
Okay. That's good because everybody's always asking me that. What is the difference, though, between a revocable and irrevocable trust? I'm sure you get that one a lot.
I do. So everyone thinks that maybe an irrevocable trust is the way to go. However, an irrevocable trust, we mainly use it for tax purposes, and you're basically saying, I am giving away my ownership. I am no longer, the owner of these assets, and the IRS treats it as such and gives you a tax exemption. You see the real benefit of an irrevocable trust if you have a taxable estate. It changes every year. Right now it's over $15 million. A revocable trust, you can change, you can do whatever you want to it. You maintain full ownership and control of all your assets. So, most people, I would recommend a revocable trust.
An irrevocable trust?
A revocable trust. An irrevocable trust, you can't change or amend without a court order.
But that's how you avoid the inheritance tax.
Yes, correct.
But a revocable trust, you still get inheritance tax?
It depends on what the assets are. If it's just property that has usually there's no inheritance tax. In Florida, we don't have an inheritance tax. But it really depends on the assets that are in the trust.
So what do you think is the best way if you're buying a property to avoid your loved ones or your heirs to go to probate?
Definitely, if you're buying a property which you plan to live in, you can either look at a ladybird deed or a trust. If you're buying a property that you want your heirs to inherit, put it in an LLC. We can do a transfer of death clause on an operating agreement. We can also create a trust, assign your interest in that LLC to the trust, and then it'll avoid probate as well.